My name is Peter Jaffe, and I'd like to welcome all of you to our webinar called The Pandemic and Family Justice, Unequal Outcomes and Access to Justice. Our webinar today will feature outstanding researchers in the family law area that I'll introduce in a moment before they begin to speak, but we're pleased to have Claire Houston and Rachel Birnbaum from Western, and Nick Bala, Senior Professor at Queen's. Before I introduce them, just some announcements. If we look at the next slide. Just a reminder that all attendees are muted during the webinar. If you have any technical issues, please type that into the chat box and we will try to address them for you. If you have questions for the webinar speakers, type them into the Q&A box, and we'll be spending 15 minutes at the end to answer as many questions as we can. At the end, there will also be an evaluation link to give us feedback about this webinar and also give us ideas about future webinars. And there's also going to be a certificate of attendance that will be generated and emailed to you for those of you who are collecting professional development certification. The presentation slides are posted on the website in English and in French. And a reminder with code of conduct that obviously in terms of any questions and responses, if you can avoid names of any individuals or any criticism of individual professions or professionals or agencies, and obviously using appropriate language. Next slide. Before we begin, we want everyone from coast to coast to coast to think about the traditional lands that you're currently situated on, and join us in acknowledging and thanking the generations of Indigenous peoples who have cared for these lands, and in celebrating the continued strength and spirit of Indigenous peoples. The ongoing work to make the promise of truth and reconciliation real in our communities, and in particular to bring justice for murdered and missing Indigenous women and girls across the country, should inform our discussions in this webinar and beyond. Before I introduce our speakers, we wanted to do a poll just to help our speakers know where all the participants are from. So the first poll, you can answer right on screen. Where are you joining us from? Whether you're in Ontario, Quebec, the Atlantic provinces, Prairies, BC, the territories, US, or other countries. If you can click on and submit. So it looks like majority are from Ontario, but we have representatives a lot from the prairies. The next poll, wanted to ask you what your role is in attending the presentation today. Are you a lawyer, judge, mediator, an academic, working in social services, violence against women services, health or mental health, government, currently or potential litigant looking for information about access to justice, or other? Okay, so it looks like we have a real mix. Number one areas, violence against women's services. And judges are all occupied today on Zoom elsewhere. And smaller number of lawyers and social services. So Nick and Claire, you're going to have to make your legal information accessible to the general public. And Rachel, you're okay because you have a degree both in law and social work, so you can talk to both audiences easily. Just another reminder, there's messages in the chat function. It's important that if you want to hear the presentation in French, that you click the interpretation button at the bottom of the screen. And again, we'll make sure we have the slides available to you. We have some technical problems, but we'll get the link to the slides available to you. Just expand on my introduction to the three presenters today. We're very pleased first to have Claire Houston, who's assistant professor at the Faculty of Law at Western. And she comes to us with considerable expertise and interest, both in family law, criminal regulation of family relationships, and children and the law. Welcome, Claire. As well, we have Rachel Birnbaum, who is a professor at social work at King's University College, affiliated with Western University. And as I mentioned, she's unique in that she has both a law degree and a social work degree. And her primary area of teaching focuses on children and families, ethics in the law, and research methods. Welcome, Rachel. And pleased to have Nick Bala, who is probably the senior family law professor in the country, and really pleased that he could join us. And I know he's been part of this research team, professor at Queen's, the second best university in Ontario after Western. And as I mentioned, leading Canadian legal expert and scholar on issues related to children and families in the justice system. Thank you all three for being here. We're looking forward to your presentation, and clearly your research topic is not only timely, but so relevant in terms of what everyone is facing these days in terms of accessing justice. I'll turn it over to you.
Wonderful. Thank you so much, Peter. We are delighted to be here today to share our research with all of you. We'd like to thank the Center for extending the invitation. Before we begin, I would just like to acknowledge that I am calling today from London, Ontario, and so I would like to acknowledge the Anishinaabeg, Haudenosaunee, Lenape, and Attawandaron peoples whose traditional lands I am calling from today. We would also like to thank the Law Foundation of Ontario and the Association of Family and Conciliation Courts, the Ontario chapter, for funding this research. We're grateful to them. Next slide, please. So our presentation today is going to consist of 4 parts. We're going to start with an overview of the project, discussing some of our research questions and objectives. We'll then discuss a little bit of our methodology to understand how we've undertaken the study. We're then going to spend a fair amount of time going over our preliminary findings. The study is not yet complete, so what we're offering today is what we have found so far. And then we'll end with some tentative conclusions from our research and possible ways forward. Next slide, please. Next slide, please. Thank you. So this project originated as a result of the significant disruption that occurred to the family justice system in Ontario beginning in March of 2020, when the pandemic forced the physical closure of courthouses, the move to remote hearings, the limiting of hearings to matters that were considered urgent or emergency, and the effect of family professionals having to pivot to deliver legal services in a different way. The closures and associated disruption led us to consider how this was going to impact a system that was already facing some significant access to justice concerns. So namely the cost of legal services, the complexity of taking a case through court, and also delay within the system. We wanted to think a little bit about how the pandemic was going to exacerbate or affect some of these issues. So our first research question in developing this study was to think about how the pandemic had impacted the system. We were curious also about how the pandemic, the effects of the pandemic might be affecting different groups and potentially differently. And then we also wanted to think about how the pandemic might encourage changes in the system that we might be able to continue either as they are or with some modifications moving forward. So was there anything that we could learn from the pandemic that might help to improve family justice moving forward? Next slide, please.
Thank you, Claire. Next slide, please. So the research that we've done and that also helps to inform is not only just simply surveys that we send out online, but also interviewing. So this was a mixed method approach, and they really inform one another about, you get some information by asking a question in a survey, but when you follow up with individuals, you get far richer information and helps us tease out what some of the real issues are. So we initially started with the survey data, which we're going to talk about later on today, which is the that we sent out to family justice professionals in Ontario, as well as a review of the case law, both during the closure, and then now we're doing a follow-up of what's happened after the lockdown. However, we're back into a lockdown, so we're going to have to come up with a new title for it or a new way of explaining it. And then we've teased that with qualitative data, interviewing, which we will be doing with some self-represented litigants, with mental health professionals, lawyers, as well as judges. So you can see that it's a rich way of gathering information and getting more nuanced into the issues about what's really going on during this pandemic, particularly in Ontario. Next slide, please. So the analysis of reported Ontario family law decisions was broken down into, as I said, the lockdown period, which was from March to July of 2020, and the reopening period. And I wish I could say that it's still reopening, but now we're back in lockdown. So, and that's from July 2020 to March 21. We may revisit this in terms of, what happened again during lockdown, but we'll see. And as I said, the survey of professionals, which were the mental health professionals, lawyers, judges, court-affiliated people, and interviews with the professionals and self-represented litigants. Next slide, please. So the survey that we're going to focus on mostly today is had about 91 people who responded. 54% were lawyers, and as you can see, what happens with most surveys that we found with many different surveys, 77% of them identified as female. There were 21% that were mental health professionals, and then there were 4% who were judges, and then a mixture of other supervised access facilitators, mediators, etc. And they had a rather a good experience in terms of 21 years or more in the family justice system. So we were really getting the responses from people who are very much involved, both pre, present, and post, to really help us understand what some of the issues are. Next slide, please. So the lockdown cases were all the reported Ontario family law decisions between March and July of 2020, and there were 506. And we went over this several times. And again, they're all reported. I'm more than sure that there were judges who made decisions and never submitted them to be reported. I'm sure there were other issues, but we had no access to that. We could only look at what the reported decisions were. And of those, there were 32 child protection matters and 474 domestic matters related to parenting disputes. Next slide, please.
Okay, so thank you very much, Rachel and Claire, for getting this going. I'm going to be talking about some of the findings that we've had about high conflict separation. I just want to say a word more about the case law analysis that Rachel has mentioned. I want to thank our graduate student, Kate DeVoe, who did a lot of the work around finding and analyzing those cases. And as Rachel has mentioned, these are cases on the Westlaw database. They're not all cases, but they're, if you want, all reported cases. And so it's a limitation that we don't have unreported decisions, although all research about law has that limitation. Next slide, please. So what we found, and as Rachel said, we have a convergence of different methodologies. I think the one of the broad findings is that the pandemic has increased tensions within families, and I think everyone is aware of that. I think in some ways, tensions and stresses. It's also brought forward strength and resilience in many situations. But conflict within families, especially, and here we're using families, separated parents, and also part of our study is a little bit about what was going on in families that were co-residing, but there was tension within the families, particularly around issues around family violence, and then they separated during the pandemic. And part of the idea behind looking at the so-called first lockdown period is people were finding it very hard to leave situations where there was marital strife and abuse going forward. So some of our key findings have been that there was an increase in conflict, in particular for this research purposes, among those who've separated, but also more likelihood that there was tensions around issues like joint or shared parenting or access visitation issues, and also within families that were in the same unit, increased stress, the stress of economic issues, of closing of schools, and increased parenting issues, uncertainty, health concerns have all led to an increase in conflict. And then around families where the parents have separated, one of the issues, and we'll be talking about it more, is that there were increasing conflicts over the issue of what we can call access, although the terminology has now changed, parenting time, but one parent withholding children from the other parent. In some cases, the parents were taking advantage of the pandemic. In other cases, the pandemic was raising important issues, for example, about family violence, where there were legitimate reasons to withhold contact or expect supervision. And certainly an overriding theme through the past year has been a concern about lack of access to the court system, and that courts are where disputes are resolved and also where protection can be achieved, or a degree of protection or resolution. The direct impact on the families or the parents, the litigants, but also the indirect impact that this has on children. And of course, it's not only courts, and in fact, in some ways, the courts have been able to respond more than, for example, lack of access to support service in the community, to mental health counseling, to information services about the justice system. For example, legal aid, although legal aid has continued to function, in particular the services of what we call duty counsel or advice counsel in Ontario, where someone who doesn't have a lawyer can walk into a court and meet with a lawyer, courthouse, can walk into and arrange to see a lawyer for 20 minutes or a half an hour to get some initial information. Those services have been effectively shut down. There are telephone services, but they have problems with them in terms of accessibility. Next slide, please. So in the survey, and we asked a number of questions, and you can see this graph is one that you'll see repeated in different ways with different kinds of questions. So one of the questions we asked the 91 professionals is, and we divide this, as Rachel said, into the lockdown period. When we were asking the questions, people knew what lockdown meant to the beginning of July, and then reopening, as Rachel has pointed out, good question, how we would describe it now, lockdown number 2. But in that lockdown period, the report was that there was an increase, and you can see many of the respondents, and really about half, said that there was an increase in high conflict cases that they were seeing. And it's understandable, by the way, that different professionals who have different kinds of practices and in different communities are seeing different things. So the variation there, as much as anything else, reflects those professional experiences. But I think overall, we were seeing a significant increase in conflict. And as we'll discuss, both the amount of it or the extent of it, the number of couples affected, number of partners affected, and also the increased intensity within relationships. So next slide, please. So again, here in the reopening period, and this survey was done in the winter period, roughly December, January, and asking the question about how do you compare the reopening. Again, high conflict. We were comparing the reopening period to the pre-pandemic period, and again, people were seeing significantly more conflict. Although here we have a significant number of people in that bottom graph saying they're not sure about the effect, and that would be understandable. Some professionals would, particularly again during that initial period, were not seeing clients or being involved. One of the interesting things as we move from the lockdown to the reopening period is in the lockdown period, a lot of both the courts and professionals were thinking about how to function in this new virtual environment. Many professionals, agencies have transitioned, some more successfully than others. When I say successfully, it's a reflection of resources, the kind of clientele that we're dealing with. Later on, we're going to come to the issue of how litigants, parents, victims of violence have been affected by the new technological environment, and essentially finding that there were some situations that are actually improved by technology, by the pandemic and the shift to a technological, and many where there were those who were negatively affected, sometimes quite dramatically. So next slide, please. So as Rachel identified, we found cases in the lockdown period, and there were about 500 of those cases. And one of the things, and from a lawyer's point of view, during the initial lockdown period, and I should say during the present period as well, one of the legal hallmarks of this period was that people could only get in front of a judge. When I say in front of, whether on Zoom or teleconference or even in writing, they could only have their matter brought before a judge if there was a finding in that period that their matter was urgent. And certainly family violence issues are urgent. Denial of contact with children is urgent. In some situations, lack of economic support is urgent, but many cases traditionally appearing in the family courts or regularly appearing in the family courts would not be considered urgent. And so judges were having this process of first deciding, is the matter urgent, so-called triage judge. One judge would look at the material submitted and say, is this urgent? And then decide that it should be heard or not. So that's what we were looking at in terms of the 500 or so cases in the lockdown period. And one of the things that we found was that judges were using high conflict language. They were characterizing cases as high conflict in about 40% of cases in high conflict, or sometimes they refer to it as a battle going on, high levels of animosity. And I should say that compares ordinarily with judges using that language in about 4% of cases. So we saw a 10-fold percentage increase. Now, fewer cases are coming before the courts, but of those cases, there's a higher level of conflict as characterized by the judges and or the parties. And many of the cases, in fact, one of the things we were wondering as we started the study, and we began it really as the lockdown was coming, and then gradually evolved a research methodology and so on. One of the questions we had, or we thought, was how would people who were living together during the pandemic and then separated during the lockdown period, how would they be responding? And then we also recognized there were people who had separated maybe 2 or 3 years ago and then moved into the lockdown period. And in fact, one of the things that we found was that most of the cases that were appearing in front of the courts were cases where the parties separated prior to the pandemic and lockdown. So even people, and here at the test, they have to show that it's urgent. So people who may have separated in 2019 may have been getting along somewhat or not, then we're saying now it's urgent that we get before the courts. And many of the cases then were cases that were referred to by judges with terminology. And here's a quote from one case saying, this case has had a long acrimonious litigation history, which has been exacerbated by these very concerning times amid the COVID-19 crisis. So that was actually a dominant theme of all of these cases. And indeed, in some cases, people were coming back more than once in that first 5-month period and saying, this is urgent. And so we saw that increased levels of conflict and ongoing conflict. Next slide, please. So we were looking both at case law and also the survey of professionals. And as mentioned, we're now going to be interviewing professionals. So in the survey, and there were some graphic quotes here, as one professional reported, the pandemic has thrown gasoline on high conflict families. So those families that are already separated, things got worse as they had issues around schooling, around children going back and forth, around health concerns. And I think, one of the often people were focusing on saying, well, I'm very worried about my children going back and forth. One of the messages from the courts, and we'll see this in a moment, is that despite the pandemic, there was an expectation that contact with children would go forward, that visitation arrangements or parenting schedules would continue forward, but parents were aware of the fact that the pandemic was going on, and influenced by it, conflict often increased. And here again, a couple more quotes, that high conflict families, the conflict was increasing. And there was more to fight about. One of the concerns in terms of the effect of the pandemic on children is that not only was conflict and particularly both intact and separated parents, but in intact families, when I say intact, families where parents were continuing to reside together, often there had already been conflict and violence, but now children were seeing more of it because they were living in the home 24/7, as opposed to they go to school, the parents might fight when the children, or there'd be abuse. As serious a concern as domestic violence when the children were out of the house, now children were more likely to see it. And so there have been concerns by many, and I'm sure many in this audience, about children witnessing more conflict, more violence within their homes. Next slide, please. So one of the dominant themes in both the surveys and the case law has been that the single greatest or most frequently litigated issue has been issues around parenting during the pandemic. And in particular situations where they're about whether or not what we hear called access, and of course, if you want parenting time schedules would carry on. And one of the very early statements there's a reference there to a case called Ribeiro and Wright, which has become a very well-known case among lawyers and judges, not only in Ontario, but across Canada. And I should say those sites there, although we were looking at Westlaw case law, those sites that we have in this presentation, you can find, they're all Googleable on the free website Canley. And in Ribeiro and Wright, and then many other cases that were going forward, judges said that visitation arrangements with parents presumptively should continue. Ones that had been in place prior to the pandemic should continue. As one judge, Justice McGee said, Ontario said, that, and there was a discussion, what services will remain open? Are liquor stores an essential service? They said only essential services. Yes, liquor stores, marijuana shops are essential. And so Justice McGee said, parenting is an essential service. And the fact that there has been a pandemic and schools are shut does not mean that visitation should not go on. So one of the things that happened, you may recall, is we started the pandemic in Ontario during the March break for many people. And some people said, oh, well, the arrangement we had said when school resumes, we'll do something, but school is not resumed. So I had the children over during the March break, and I'll just keep them until school reopens. And people will get in front of the courts, and the court said that's not what is reasonable. That's not what is child focused. Now, having said that, there are certainly cases where it was appropriate and necessary to respond to the poor parenting during the pandemic, and say that one parent was not following health guidelines, was exposing children to risk. But the courts were expecting people to do that in a reasonable way, and it was a great challenge. Certainly one of the things was it was not sufficient to say, I'm concerned about my partner, my former partner, the other parent of the children, not following the health guidelines. She's never followed any rules at all. So I don't think she's going to follow the rules from the government about this. I don't think she should have time with the children. There was an onus on a person having concern that the health guidelines would not be followed to establish that that was occurring. And of course, that can be a real challenge. But there were cases where it was established that health guidelines were not being followed and visitation was suspended or supervised. One of the challenges during the pandemic was, how do you supervise visitation? Visitation centers have been shut down. So some real challenges going forward. But the message of the courts was, ordinarily parent-child relationship should continue, if necessary with modification, taking account of the fact that schools were closed and otherwise, and expecting that parents would compromise. And again, there were many judicial statements about the need for parents to be flexible and compromise. And I should say, in the vast majority of cases, people not going to the courts, parents have been flexible, resilient. There are certainly concerns about the higher conflict families, about cases where there has been family violence, which is, of course, a tremendous concern. And that's, to some extent, our focus today. But it's important to recognize as a society that a majority of separated parents have continued to cooperate, and indeed seen the value and need for cooperation as their children are at home much more, wanting to share that responsibility. In fact, often the question has been, has parenting been appropriately shared? Next slide, please. So certainly one of the focuses of concern has been that the courts were, initially the courts really just for a day or two, they were completely shut, and then they said we're going to have online access. What does online access mean? For lawyers, many lawyers, particularly those in private practice, were able to adjust fairly quickly to the online environment. And in some ways, the online environment has actually been easier for lawyers to access. But of course, for litigants, particularly those who don't have access to technology like Zoom, are not aware of how the websites were operating, it was very challenging. It has been and continues to be very challenging to get access to the courts in a timely way. And people who in the past might have been able to go down, see someone, people who didn't have lawyers, see someone in a court office, file some documents, get in front of a court within a week or so, that has been much more challenging for people waiting and wondering what is going to be happening. And furthermore, there have been challenges that ultimately it's the children who are suffering while parents are continuing to carry on disputes. And here, for example, I mentioned Ribeiro and Wright, this decision of Justice Pazaratz, who was emphasizing that as much as possible, parents should be cooperating. And of course, that was true perhaps in a majority of cases, but not those who were coming before the courts. Another statement that has been made by some judges is that this is the challenge of a lifetime. And I think in some ways, this is for many of us, from a societal perspective, that we're facing challenges that we've never faced before in Canada or not in our lifetimes. And the judges were saying, how you respond now will be remembered not only by the courts, if you're here after the pandemic, how you behave during the pandemic will be significant. And furthermore, it's something your children will remember. So think about how you want your children to remember how you behaved during the pandemic. Next slide, please.
Great, thank you, Nick. So One of the other themes that we wanted to explore in the project was how the pandemic had impacted both rates of family violence, but also victims of family violence. And I'm using the term family violence here broadly to encompass both intimate partner violence or domestic violence, but also abuse and neglect of children. So we're putting those together for the purposes of this presentation. And so again, what we were looking at here were the 506 cases that were reported that had been heard during that initial lockdown period, but also the survey responses. And so what we found from those two data sets are a couple of things. So one, we're seeing concerns, particularly among survey participants, about an increase in family violence during the pandemic. And this is something that we've heard about from other outlets and from other researchers. And not only an increase in the rates of family violence, but also in terms of severity. So violence looking a little bit different during the pandemic than it had pre-pandemic. And that was especially with respect to intimate partner violence. We also learned about more barriers to leaving. So we learned from survey participants about the particular barriers that victims were facing in the pandemic to leaving abusive situations, and also accessing support during the pandemic to deal with violence and find safety. And then finally, although we did not do a comprehensive survey on the impact of the pandemic on the child welfare system, we did ask questions about rates of child abuse and neglect. And also we asked participants what they thought the impact of the pandemic had been on the work of child protection agencies. So we can share some of that data with you today. But again, it's fairly limited in terms of what we're learning about how the child protection system responded to the pandemic. And that's certainly an area of research that needs to be explored further. Next slide, please. So again, we asked survey respondents what they thought the rates of intimate partner violence were during the pandemic as opposed to before the pandemic. And we asked about two separate periods. So the lockdown period, the period from March to July, and then the reopening period, which was post-July. And what we found from the survey respondents is that many of them believed that there had been more intimate partner violence during the lockdown period as compared to the period before the pandemic. And next slide, please. We also had a similar response to the question of what rate of domestic violence individuals perceived was occurring in the reopening phase. So again, survey respondents were concerned about an increase in violence during the pandemic, and this accords with other information that we've been receiving from other outlets about an increase in violence during this period. Next slide, please. We also asked survey respondents about whether or not they thought that rates of child abuse and neglect had increased during the lockdown period and the reopening period. And again, you can see that the majority of participants thought that there had been more child abuse and neglect in the lockdown period. And next slide. And that they were somewhat concerned about an increase in abuse and neglect in the reopening period. Next slide. So looking at the cases that were heard during the lockdown period, we found that there had been allegations of intimate partner violence in about a quarter of those cases, which is a fairly significant amount. We also looked at the number of cases that involved intimate partner violence allegations that were part of the triage system. So as Nick explained, in Ontario at the beginning of the pandemic, there was a system in place where judges would first determine whether or not a case was urgent. And if it was urgent, then the case would be referred to a second judge, potentially, or even the first judge, to determine whether relief should be granted on the motion. So we found that in the triage cases where judges had determined that the matter was urgent, that there were allegations of intimate partner violence in a quarter of those cases also. So similar rate to the non-triaged cases. We did the same analysis when looking at cases involving child abuse and neglect allegations, and we found that there were allegations in about 11% of the total cases, as well as in 11% of the cases where the judges had determined that a matter would proceed to be heard past the urgency phase. And one thing that we learned is that we couldn't seem to find a relationship between judges determining that a matter was urgent and the presence of family violence allegations. So we were not seeing judges referring matters on or finding that they were urgent where there was allegations. There wasn't necessarily a relationship between allegations being made and cases being found to be urgent. Next slide, please. So we asked survey respondents, and again, these were lawyers, mental health professionals, other family justice professionals, and a few judges, what they thought the impact of the pandemic had been on victims of intimate partner violence. And there were a number of themes that came out of the survey. The first is that although respondents were reporting that they had sensed that there had been an increase in violence or an increase in severity of violence, this was coupled with lack of supports for victims and also barriers to leaving. So at the same time that there's potentially more violence or more severe violence, we're also seeing it more difficult for victims to get help. One of the issues that participants described was a difficulty among victims of intimate partner violence accessing courts. And so one of the common themes that arose was the issue of delay and the fact that victims were not able to get before the courts as fast as would be appropriate for remedies like restraining orders. And we have a quote here from one of the participants who say that for things like restraining orders, there's been a 5 to 6 week delay in getting motions heard, and they describe that as a crisis. One of the other points that was made was the fact that perhaps the delays in the justice system were also contributing to victims staying in unsafe situations longer than they otherwise would have. So another participant explained that there's this fear among victims that they will not want to start the court process because it takes so long that they're avoiding the court process and therefore staying in relationships longer, not receiving orders from the court for a longer period. Next slide, please. So while most of the survey respondents suggested that they were concerned about the impact of the pandemic on victims of intimate partner violence, there were a few who suggested that they had not seen a real impact on victims. This may be a function of different systems operating differently. So one respondent said that they were pleased that the triage urgent motion process was responsive enough to provide safety-focused orders for victims of intimate partner violence. So it wasn't across the board that survey participants had concerns about the way these cases were being handled. Again, when we're talking about concerns that participants were expressing around how victims were faring during the pandemic, one of the key points that came up again and again was the fact that, although there is this increase in violence or potential changes to the severity, there are really limited options for victims during the pandemic. And one thing that we learned or that we heard about was the fact that victims felt as if they had really nowhere to go. So the participants suggested that shelters were full, that victims were fearful of living in congregate settings with their children. They were staying at home because of stay-at-home orders. They were reluctant to rely on family and friends as a result of fear around spreading COVID or contracting COVID. And so as a result, they were staying in the home in potentially unsafe situations. And what a few respondents indicated was that the particular vulnerabilities experienced by victims of intimate partner violence may have been disproportionately felt by racialized people. So Black Canadians and also Indigenous victims. And again, that's an area that needs to be further explored to try to better understand how the pandemic has affected different victims of family violence differently. Next slide, please. So again, as I mentioned, we explored a little bit how the pandemic had impacted the child protection system. And one of the questions that we asked on the survey was, how has the pandemic affected the work of child protection agencies? And a consistent refrain was a concern around child protection agencies not being able to have eyes and ears on children because of community members not seeing kids as frequently as they would have, and therefore not being able to make referrals to child protection services. So for example, kids not being in school means that teachers are not reporting potential maltreatment to child protection agencies. We're just not seeing it as much as we would have had the children continued to be at school, for example. But we also heard mixed reports on whether child protection agencies were seeing an increase in referrals. So some survey participants thought that there had been an increase, that child protection agencies were overwhelmed by referrals because of increased stresses in the home, potentially more intimate partner violence, more substance use by parents, more conflict between parents, as we mentioned earlier, and that could lead to more reports. At the same time, other participants thought that child protection agencies were not as busy because, as I mentioned, they were just not getting the same number of community referrals that they would have received pre-pandemic. Next slide, please. So again, a couple other things that came up in the surveys about the work of child protection agencies. A couple of people mentioned that this work was becoming very, very difficult. Not only because of not being able to see children, but because of workers having to place themselves at risk. So having to enter homes where they had fears about contracting COVID, not being able to actually go into homes, having to meet children on porches, and not being able to get sort of an effective assessment of what was happening in the home. Concerns about workers being overwhelmed by the number of referrals and having to take time off, which then further strained the system and potentially resulted in less protection of children because of that. And then there were also some real concerns about the way that child protection agencies had responded during the pandemic. So one significant issue that occurred in Ontario was that child protection agencies decided that they would suspend access between children who were in care and parents, suspend physical access between parents and children. And that created obviously some significant issues for families who wanted to see their children, and also children who wanted to see their family members. And so there was a court decision that determined that had to stop, that child protection agencies had to try to facilitate access where possible. But that initial decision to cut off access seemed to affect families in a major way. Next slide, please.
Thank you. So as Claire has identified, the issues in the family justice system, which really reflect broader societal issues that are being identified by other researchers, have really exacerbated many of the tensions and inequalities in Canadian society, in particular in this context, victims of family violence, women, members of visible minorities, Indigenous peoples have really been suffering and negatively impacted by the pandemic and what's been happening in the courts. And I'm going to talk now about self-representation, those litigants who don't have lawyers. Most of them, they don't have lawyers because they can't afford a lawyer, because they can't get access to legal aid. A small minority, I think, might choose to be self-representing for various reasons. And I should say some other work that Rachel and I have identified is that males may be more likely to self-represent by choice than females. So next slide, please. So in the survey, one of the questions we were asking was, in the lockdown period, were you seeing more self-represented litigants. And here again, although many people, many lawyers, mediators, and others said yes, there were also a significant number said no. It was about the same, or indeed even somewhat less. So here perhaps a little less impact from the lockdown. And then the next slide, please. And a fairly similar picture in the reopening period. What was the impact on the numbers of self-represented litigants? Yes, somewhat more. People were having difficulty finding lawyers. And I should say in both periods, some lawyers have, particularly in the lockdown period, effectively shut their offices. And even now, or perhaps again now, some law firms are shut down. Certainly there are issues about access to legal aid, and legal aid has, I want to say that, many people in the legal aid system have been, legal aid staff lawyers have really been struggling to meet their responsibilities, but on a systemic level, it's been an enormous problem that people are having difficulty in getting access to legal aid, telephone access, and so on. Next slide, please. So one of the things, asking about self-represented litigants, if one looks in the court system, one sees, that the majority of parties were having lawyers. In fact, if one looks at reported cases, the rate of self-representation actually went down during the lockdown period. And what that means is those who were self-represented had more difficulty. They weren't getting in front of the courts. So that was a major issue. Self-represented people simply were not getting access to court. Did that mean they were staying in abusive relationships? They were not getting the support they needed, the economic support they were entitled to? What was the effect of that on their children? So that's actually a significant, very significant concern. During this period, we did find that women were somewhat more likely to have lawyers than men. That reflects the fact that legal aid does give some priority to victims of family violence and women in various kinds of situations. So while the legal aid response has been in some ways problematic, it's also they have been struggling to deal with a real crisis. And certainly one of the issues is that our family lawyers prepared to accept legal aid certificates, although some of them are not, and many of them are not. There are also, I think, in most communities, some lawyers who are prepared to accept legal aid, but it became even more challenging during the lockdown period. Next slide, please. So one of the issues in the lockdown period, and indeed continuing now throughout, has been the fact that in Ontario courts, we've had family law information centers, FLICs, which I think were important sources of information. There are also, in most family courts, there are duty counsel, lawyers paid by legal aid, advice counsel, lawyers who can talk to people either coming to court the day of court or at some other time just say, I need some advice. Actually, I probably want a lot of advice, but can I get access to any advice from a lawyer? And yes, you can. Legal aid would provide services. The fact that courthouses are closed or were closed or more or less continue to be closed has had an enormous impact on that walk-in, if you want, clientele, people coming to get advice from court clerks and court staff have been very much negatively affected. And on top of this, what we have is the way that the justice system has responded, and this, as best it can, has been through a series of what are called practice directions, material that's emailed out, that is placed on websites. And it is there, I mean, in fairness to the courts, and for lawyers who are familiar with it, it's actually in some ways a better environment to be practicing in, because they can sit in their office and be in one court for an hour and then be in another court an hour's drive away the next hour. So it's actually in some ways a better model. But for those who are self-represented, it's enormously difficult to find out information. It was already a challenge before. Organizations like Clio have provided good information, but it's a one-time thing, and now people need new information every week. They say there are websites, but just figuring out where they are and how to get access to them is an enormous challenge for those who are self-represented. And of course, that ultimately means they're not getting before the courts and they're losing access to their rights and protections the courts can provide. Next slide, please. So I should say that and this is an important comment, that for family justice professionals, lawyers, judges, mediators, court staff, in some ways, the result of the pandemic has been positive in that we've really shifted from a paper-based system to an electronic system, and it's had an enormously positive impact on moving the system forward. Having said that, for those without access, proper access to the internet, for example, who would say, well, I had to go to the public library to get the public libraries closed, those without access to proper access to cell phones, limited time, it's been an enormous challenge and a loss of access of justice. And again, Claire mentioned the child protection system, and we haven't done enough to fully study that, but it's clear that the child protection system, those involved parents, many of them things have been even more challenging. Now, again, there are situations where it's been advantageous in that parents who live in rural Ontario who may not have had access to transportation can at least phone the court if they have a cell plan that will let them, they can at least participate in some way. In the past, perhaps they couldn't, but on the whole, the child protection issues are very significant and serious, both for parents and children. Next slide, please.
Great, thank you, Nick. So as Nick mentioned, one of the most significant changes that has occurred as a result of the pandemic is this shift in the family justice system from a paper-based system to an electronic system. And that includes the ability to file documents online as opposed to going into the courthouses to file court documents. It also includes this move to remote hearings, whether they be by telephone or by video conference services like Zoom. And so one of the questions that we asked survey respondents about was how technology has changed and what that impact has been. And so I want to talk just briefly about some technology concerns for those who are experiencing family violence. Next slide, please. So we heard some mixed thoughts about the use of technology. One of the pros, according to respondents, was that being able to attend court from home as opposed to going to the actual courthouse can add to safety for victims. And so avoiding confrontation or seeing a perpetrator in person can be beneficial for victims. Some of the cons that we heard about were some of the potential breaking of boundaries in having remote hearings and virtual access, parenting time taking place for victims. So we heard about the discomfort that can be experienced from hearing a perpetrator's voice in the home, being concerned about the perpetrator seeing the inside of a victim's home, discovering the victim's phone number, etc. We heard from one participant about judges ordering virtual access where a no contact order was in place. And this participant suggested that that had led to more allegations of intimate partner violence. So that was obviously a concern. Next slide, please. So again, what we heard, both in the context of family violence victims, but also just generally, is that this move towards new technology is really changing the way that people are accessing justice. And so one of the refrains was, access to justice now means access to technology. And without that technology, access to justice suffers. And so we heard about victims having difficulty speaking with counsel and attending court hearings because they do not have access to computers, for example. And also the difficulty of trying to access services remotely when in the home with the perpetrator. So we had one respondent say that they've had clients call from cupboards in the basement, trying to find privacy within the home. So obviously, the inability to leave the home to access services can place victims at greater risk. Next slide, please.
Thank you, Claire and Nick. Next slide, please. I just want to talk a little bit about the impacts and kind of bring it to a close. And I should have said earlier, when we're talking, these are the survey responses. So we would ask a question and then sometimes we would say, please explain. So when we're giving you the quotes, it's please explain, but not of the interviews that we're doing, but rather the please explain that's in the survey. And much like everything that we're finding out with this vaccine rollout across the country is similar to what's happening with access to justice with these lockdowns. It has been a real mixed bag. There's been a lot of pros, but there's also a lot of cons, particularly when it comes to victims of family violence. And we tried to differentiate high conflict families, which is not the same thing as, you know, as domestic violence issues. There may be some behaviors in high conflict families, but they're not the same as domestic violence families. And as much as we tried to separate that and and kind of tease that out, we also did much more of that when we were able to interview some of the litigants, but that'll be some of our results coming out. So there's a lot of negative impact on these high conflict families. These are the families that have poor communication, poor cooperation, and particularly on the children. And it's being exacerbated because many of these parents cannot get access to the courts. You heard earlier Claire talk about, well, it's great for lawyers. They get to know what all the rules are in all their different districts. But it's very confusing for self-represented litigants who had difficulties before this pandemic started accessing the courts and are even having more difficulties now, because if you go on any Ontario government website on any day, you will see it constantly being changed of what the rules are. And today we're going to be open, tomorrow we're not, judges are only hearing this. Lawyers have much more easy access to it and certainly have the ability to find out that information from their colleagues, but not so with self-represented litigants. So there is a real increased risk to family violence victims, particularly with these remote hearings and the pandemic-related innovations that are really increasing risk. And it's very concerning because what we found was that self-represented litigants were, particularly in our other study, that they were not being heard as much as lawyers were being heard. So lawyers are getting access to the courts and to these judges, but not these self-represented litigants. And that is also concerning with respect to family violence issues. Next slide, please. So moving forward, we're going to really take a look in a much more nuanced way with the interviews with the mental health professionals, with the lawyers, with the judges. We've done both a survey, an online survey of the judges, as well as we're now interviewing quite a number of judges to help unpack a lot of these issues that you can't get at an online survey. Just simply ask a question, you give an answer, and we can't go, yes, but what about this? And that's what we're going to do in our interviews. The technological innovations have had very disparate impacts. For people who have access to the internet and they can afford it, it's been great. For others, it's not been so great. You know, we've already heard across Canada many times where, you know, Bell is down or Rogers is down, and that has a real impact, particularly if you're trying to be in court that day. So improving access to justice may help mitigate some of these disparate impacts, but access to justice now actually means access to technology. And that is a disturbing thought and a disturbing trend, particularly when it comes to trying to protect victims of family violence and children. So there needs to be ensuring some essential in-person services, supervised access. Most of these supervised access sites were shut down, both government-wise and child welfare, but now they're trying to do more online, but that too comes with its challenges. Child protection services, while they're up and running, it still is a bit challenging. I remember speaking to one child welfare worker going, we're trying to make porch visits, meaning they're trying to meet people in at least outside their house. But now with what we have now in Ontario, for those that don't know across Canada, we are in a real lockdown where we're not to go out at all except for doctor's appointments or to go get your vaccine. So there needs to be more summary legal advice and information, and people are really trying. I mean, don't get us wrong that these services are not available, but it's a real hit and miss. It's trying to match people who have who at that time to get these services. So I don't want you to think or leave you with the impression that none of these things are working. They are. It's just very challenging sometimes to access them. And particularly when you're also having to look after children, because now all the schools are shut down. So children are online learning, which is exacerbating all of these issues. So you've got your kids on laptops and computers, you've got parents on laptops and computers, and internet in Canada is extremely expensive compared to other countries, and not everybody can afford it, and that too impacts. Next slide, please. We've now actually we've been able to finish a bit early to hear some of what your questions are, and we'd be happy to answer them as best we can.
Okay. Thank you, all three of you, for a great presentation. You covered a lot of issues, and you really highlighted some of the challenges. And there's lots of great questions. So maybe I'll just pick some to get us going. There's one question that came in on the chat function about the concern of lack of access to justice, sort of forcing more clients being pushed into mediation, which may be especially concerning for survivors of intimate partner violence. Any thoughts or reflections on that issue?
Well, that's not a problem that's been only solely as a result of this pandemic. That's been an issue that's been highlighted and raised pre-pandemic, particularly when there are victims of domestic violence and they're being asked to negotiate with the other party. Yes, we hear about this, but he still or she, he still is able to see the child. So it's an ongoing struggle. And also it depends on the particular jurisdiction, on the particular judge, even the particular lawyer, and how much understanding they have about family violence. But the vast majority of family mediators, first of all, do screening for domestic violence, and if they believe that it's on the coercive controlling end of this, they will not proceed. Now, I can't say not all of them, but they're very attuned to these particular issues. But it is an ongoing issue. I make no apologies for it.
Okay.
So, and if I could add, one of the many services that was affected by the pandemic were mediation service. Of course, in Ontario, we have both private mediators and mediation through government subsidized programs at the family courts. Initially, they were effectively shut down. Many of those services have now shifted to online, to Zoom mediation. And again, like other things, some cases actually Zoom mediation may be better than in person. Some cases it's more problematic. And of course, that assumes that people have access to Zoom and the technology, which many people don't. It's probably true that the pandemic has, one of the messages is you can't go to court. So people are saying, well, what can I do? And somebody says, well, here's, you can go to mediation. And yes, there should be screening, and that's certainly part of the government mandate. How effective is it always? That's not been our research mandate, but there are legitimate questions about that. So there's certainly fair concerns to be raising.
A question that's come up several times, and I think Rachel, you I think you answered it in part, but maybe, I don't know if any of the three of you want to expand on this. There's always a concern about the difference between the term high conflict, which may be broad of a number of cases that are before the court and not settling readily, and intimate partner violence, and whether some of the high conflict you're describing includes those cases or those are distinct. It might be helpful, since we have several questions, it might be helpful to expand on the answer.
So first of all, this survey, as I said, we tried to differentiate between high conflict of poor communication, poor problem solving versus intimate partner violence, the more coercive, controlling kind. But it's very hard to tease that out. I regret very much, the term high conflict came from Janet Johnson, a sociologist down in California in the late 70s, early 80s. And she was looking at families simply from the view of conflict between the parties, about poor communication, poor problem solving. And it somehow morphed over the decades into everything now is high conflict. And, Nick and I have been doing a lot of work on looking at the case law over decades to see how many, how much more often it's being used. And sadly, it's being mixed in. So judges and lawyers, when they talk about high conflict, they may be talking about poor communication, poor problem solving, but then you have to actually specifically ask them, yes, but what about intimate partner violence? How did this separation take place? Was there violence? Did the children hear, see, understand what was going on? That is a whole different issue. And you can only get at that nuanced from interviewing them. And that's what we're going to do through the interviews. But I can't say that for sure it was all that clear from the surveys. And even when we asked them, can you please elaborate, it's still not that clear. So, we use some of their quotes, but it's still not clear to us that that's exactly how that they're differentiating it. And that term sadly is going to remain because it seems to be this catch-all for everybody. And it is concerning, particularly when it comes to victims of domestic violence. It is not the same thing.
I guess, and I would just expand on that and say, these terms that we use, terms that are widely used. And so when we say, for example, high conflict, one of the ways we measure that, and by no means a perfect or the only way, is to see how much are judges characterizing cases as high conflict. And one of the things that we found is that over the past decade, there's been a significant increase in Canada in cases that judges identify as high conflict and use that kind of language. Now, there's also, some would say that one could view family violence cases as a subset of high conflict cases. Some would say they're completely separate. It depends on how you're defining and why you're defining it, who's defining it. But there's no doubt that there are cases where there is a high level of emotional conflict, not necessarily abuse, and there's also certainly coercive, controlling, emotional abuse without there being family violence. But there are cases where there's high conflict between two people that do not involve violence, that certainly raise concerns about the welfare of children. And then there are cases where there is violence and there are different overlapping concerns. And I think certainly in terms of identifying cases, understanding how to respond, deciding how to respond, it's important to look at the specific facts of individual cases. And certainly, one of the things we haven't mentioned, in the midst of all this, we have new legislation in Ontario, across Canada, the Divorce Act, and in Ontario, the Bill 207 changes that specifically recognize that family violence is a factor in parenting cases, and furthermore require that courts give priority to protection of the safety and well-being of children, including their physical safety. Whether courts are actually doing that, how much that is happening, is a good question. In my own personal view, often the issue is that there's, our courts are based on evidence. And in some cases, there may be family violence going on, but it's not being proven to in court. And so there's an onus on those who are advocates and supporters of victims of violence to bring forward evidence, which can be a challenge, particularly in the context of a pandemic.
Just to expand on the question, there's a couple other sub questions that I saw in the Q&A function, and that is in terms of even defining violence. If you're looking at ongoing research in this area and looking at intimate partner violence or domestic violence, will you be using a comprehensive definition? Given, for example, Nick, your reference to the Divorce Act, and now family violence is defined much more broadly, including coercive control. So it's much more than physical and sexual violence. Will you be looking at that in your research?
Yeah, absolutely. We're going to try and break it down, and what kind of behaviors are you talking? So when people say violence, what types of behaviors are they talking about? But you can't get that from an online survey. We're hoping to get some of that from the interviews with the self-represented litigants, hopefully, as well as the mental health professionals and lawyers. But again, we're talking about, there are differences in responses in terms of whether you're talking to groups from shelters, groups from domestic violence advocacy communities versus lawyers versus judges. And they all have a very different, they come at this from a very different lens. Each of them are correct, but they're seeing the world from a very different lens. And it's important to also understand that and to tease that out. So you're not going to get the same, I believe, that necessarily the same full understanding of a lawyer who's not always practicing family law, who may not have been exposed to clients where there is intimate partner violence, versus the advocate who's working with the woman. And so this takes time, and there's also limitations to all the research with respect to this, but we're certainly quite well aware of it and trying to do our best to tease some of this out. Will it be perfect? Absolutely not.
Actually, another question that's come up is looking at the impact on different ethnic communities and whether that's going to be possible within either the existing research or the future research you're planning.
Yeah. Well, if we had $1 million, we could probably do all of the above, but we don't, and we have a limited time. We certainly are looking at issues with respect to Indigenous, different cultural groups. But again, we're asking professionals. We're certainly going to hopefully get at some of that when talking to some of the self-represented.
I should say that the issue of dealing with identifying how different groups, both economic groups, those with disabilities, Indigenous, Black Canadians, are being affected by the pandemic in general, and the shutdowns or limitations to access to the family justice system are enormously important. And while we are going to try to get at some of those in the interviews that we're doing, it's certainly a question that we probably did not, the work that we've accomplished thus far has not given us the kind of data that we need to make definitive conclusions about that. One of the many challenges is in looking at court cases, which is one of our major data sources, and we do get a lot of information, for example, about allegations of family violence are almost always included in a court, at least they're either allegations or finding, or was there a conviction or whatever, you can find out about family violence. So we have quite a lot of reasonably good data about family violence. The reality is that the race of individuals who are involved in cases, while undoubtedly apparent to those in the court and often a factor in how the cases are actually dealt with, is not reported. And so it's very hard to get access to that kind of data with some of the methodologies that we've used. So that's a real limitation of this study. And certainly in future work, I think that it behooves those of us who are involved in the family justice field and family justice research, as well as those who are practicing professionals, to do more research about the disparate impacts of both family conflict and family violence on different groups. But it certainly, as Rachel has intimated, it presents challenges in terms of doing research and the funding that we have for research. And I know that the work that that this center is doing has been very important in that regard, and also continues to face challenges in terms of doing research, and something, frankly, that researchers in Canada are really only, including us, are only starting to come to grips with. I think these, are important questions. They haven't been adequately addressed. They will be. I think they're going to be a major issue for all of us going forward. And the pandemic has really heightened awareness of the issues and tensions and the need to deal with this better, first of all, on a systemic and support level, and also on a research level going forward. But that, one of the things is research takes both resources, also takes time. So we began this research a year ago. This particular study we're getting, close to the end of. We will be doing future work that tries to better address these issues.
One of the questions that's come up on the chat function here, but also has come up in previous webinars, is some of the challenges for lawyers to present cases given the limit of space. I think there's now, and again, not being a lawyer, I don't know the details of this, but some lawyers complain that you have to present your information in very limited amount of documents for the court, and trying to prove or present a case related to intimate partner violence may be very challenged within these restrictions. Is that something that the three of you?
Yeah, absolutely correct. I mean, because, for this pandemic has raised so many, I mean, just really showed the disparities in economics and race and how people are being treated, that it even more so than pre-pandemic. But yeah, some courts are saying we only want 3 pages. You can only have I have only an hour for this case conference. And these things take time to try to explain. It takes time to meet with your client. You're not even able to meet with your client. It's also by Zoom. It has become a real challenge. But having said that, I think having read a lot of the literature from other countries that are experiencing in the family justice, they're having the same issues that are being exposed as well. Everybody says, well, technology is going to make this all better. I personally do not think so. I think it's going to make it worse. These are human issues with human faces that have to be carefully listened to and thought through. There has to be services that are readily available. People are not being able to access them as easily. Not that they aren't out there, but it's just not readily accessible the way it is. And it's become a real challenge. There has to be almost an autopsy if we ever get out of this, and I certainly hope that we get out of this, about how the justice system works, and how families, children and families, are being, how they can access it really, and whether they're able to access it fully. All these studies are great. StatsCan is doing a lot of research. There are other researchers across Canada that are looking at this and identifying issues with respect to COVID. I know a lot of my colleagues in my faculty are looking at, Southeast Asian population and some of the issues that has arisen. But it takes more than just simply, sort of doing research and writing papers. It's almost like we need to have a place where we can all have a larger discussion about this, but also some problem solving, not just simply identifying. We can easily identify the issues, but we also need to start thinking about, well, how are we going to now tackle them? And I think that's the biggest issue that we have right now.
And if I could just say, because I'm reading some of the very helpful comments in the chat, the kinds of concerns that we're raising are systemic, and they're a community responsibility. I want to say that we certainly are aware of those who are working in different systems, and particularly the child protection system, but also the justice system, court staff. are incredibly, affected by these situations, and of course, many people, including workers in the justice system and the child protection system, have gotten sick as a result of their frontline work. So this is not a comment about individuals saying people aren't working hard enough. I think people are working very hard. It's a societal challenge, and hopefully, and research plays a part in this, we as a society will be doing better going forward, and making some adjustments right now. I think there are probably some adjustments, certainly I think many say, and I think this is correct, as the vaccines roll out over the course of the next few months, we will be moving back to a more normal situation, if you want, or a more open situation, but we're not going back to where we were. One of the things is we're going back to, if you want, a new normal. So in the justice system, for example, the technology changes are enormous, and many of them will continue to have an impact. So part of this research is about understanding what has happened. Part of it is trying to help the system adjust more effectively to that new normal, if you want, particularly on the technology side, but on the human service side and on the understanding side.
Just a closing question. I guess there's a couple of comments worrying about a tsunami that's going to follow. Once the courts open up, there are going to be many cases waiting, and so and obviously we don't want the system to continue to perpetuate sort of those most vulnerable not getting access. Do you have any thoughts about how we're going to manage? And as you said, Nick, this is a community and societal problem. How are we going to manage the coming tsunami of cases? Obviously, some are going to be delayed for a year or two. There's going to be a real need for triage and prioritizing cases. Any thoughts about the future?
So I think that's right, that in parts of our justice system, in fact, all of our justice system, there's an enormous backlog. Some things are being dealt with, but not just the family justice system, of course, the criminal justice system, the child protection system, the civil justice systems are all facing backlogs and cases that have to be dealt with. So triage will certainly play a role in that. And I think in fairness to people in the justice system who have been working hard to try to respond to these changes are starting to think about them. And that's why, frankly, doing research and identifying these issues is, and in our final reports, we'll be talking about possible solutions. So I think where are we going with the research? Where are governments, and not only governments, but individual professionals and agencies going and starting to plan for the post-pandemic environment? And one of the issues will be dealing with the backlog of cases. And I should say mediation will have a role in that, but also, as Rachel points out, it has to be mediation that takes account of and properly screens for family violence.
Okay. Rachel and Claire, any closing comments before I thank you and wrap up?
No, I thank everyone for listening and hanging in till now, and fabulous, just fabulous questions. More questions for us to think about seriously. We take them quite seriously, and hope to get back to you with more of some of our work.
Yeah, I also wanted to just to mention, if people did have particular questions that we didn't answer or wanted to make any suggestions about future research, please feel free to reach out. We're always hoping to learn from those who are on the ground in particular.
Okay. Well, on behalf of our center and the Alliance of Centers working on this family violence, family law project, I want to thank the three of you for your presentation. It's really an outstanding presentation. With any good research project, it's stimulating because it doesn't so much answer questions easily, but it raises more questions and it keeps people stimulated and thinking about what's important, what matters. So I think you've done a great job today getting us engaged and thinking about the future. So I appreciate that, and we hope to have you back when you've done the next phase of your study and the final report. Just a reminder for people tuning in that there's on the chat function, there's a link for the survey if you want to complete it to get your certificate of attendance, whether you're psychologist looking for continuing education credits or a lawyer, this would be a great opportunity to get that credit. And as well, we had some technical problems with the link to the slides, but on our center website, we will post a recording of this presentation. I'll edit any comments I made about Queens earlier in the presentation, but the rest will be there and links to the slides. So thank you all for being part of this. And Nick, Rachel, and Claire, thanks again. And you'll have a private email for a different link to debrief and plan our next session. Thank you all very much.